Is President Trump's new gold card replacing EB1 and EB2? Are the new H-1B fees even worth it? Reddit's panicking, but don't. We have got an immigration attorney live to set the record straight. Yes, let me introduce you to Michelle Canero, joining Immigration Talk Show for the very first time. So let me give a brief introduction about her to you guys. She is the founding partner of Canero Fadul Rais Law and one of the nation's most respected immigration attorneys with over 12 years of experience and outstanding 99.5% perm approval rate. Michelle has helped clients around the world navigate complex employment and investment visa pathways. Featured on NBC News, CNN Espanol, and the Washington Post. She is a powerful advocate for immigrants and a trusted voice in US immigration law. So we are honored to have her on Immigration Talk Show. Like I said, she's joining us for the very first time. So let's all give her a very warm welcome. Hi, Michelle. Welcome to Immigration Talk Show. Thank you so much for being here. And guys, let me tell you that we are live on LinkedIn, Twitter, YouTube, Facebook on Immigration Talk Show. So if you have any question related to our topic today, you can post them in the comments section. But before we start the show, let me begin by reading this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. A use of information is at your own risk. All right, after this very important disclaimer, welcome back, everyone. We are live, and yes, I have all the questions ready with me. And I see Ricky already has posted his question on the chats, so which I'm going to take in a bit. But before I do that, Michelle, I would like to come to you again and again give you a very warm welcome because it's your very first time. So I hope you're excited.
I am very excited. I look forward to this. Hopefully, we're able to talk about some informative stuff and clarify some of the doubts out there.
Absolutely, absolutely. I'm very sure about that we are going to absolutely do it. And Michelle, but before we get into the topic, I would like to know from you that you have built this incredible track record in employment-based immigration with a 99.5% perm approval rate. I mean, that's almost unheard of, right? So what's the secret behind this success? And, and especially success in a system that's often very chaotic, complex, and which people are very unsure of. So what's the secret?
I think it's diligence and attention to detail. I've always been a evidence person. So whenever I look at a case, the first thing I do is I look at the client's background and profile, all their prior applications. I want to make sure that the immigration history and the employment history aligns with what we're trying to strategize to present in the case. And then it's doing the due diligence, obviously, on the company, right? You can't do a perm for a company that is financially unstable. Make sure that the prior perm applications that company has done align with the strategy of the position you're doing now. So, I think it's taking the time to really understand the position, the profile, do the due diligence to make sure that the candidate actually can document the experience that's being required, that it's normal for the position. Mm-hmm. And then throughout the process, having very clear, concise documentation of information. And that's what leads to a high perm approval rate. It's, knowing the system, navigating it, but making sure that everything you're doing is accurate. And I think that's where I've seen a lot of mistakes is sloppiness in documentation, inconsistencies in, position requirements from one person to another in the same company. So that's been our secret, I guess, is just being cautious and diligent.
Wow. I mean, I think that's a recipe that everybody should follow, right? So now that we have learned about your secret, and I can see people joining us also on this, and especially Ricky. Ricky is very excited. I think he has posted a couple of questions already. So I'm very excited to take all of them. But Ricky, if you would like to get on a call with, with us and directly ask your questions, so you can also dial this number, which is presented on the screen, displayed on screen, which is 425-436-6335. Don't forget to put the access code, which is 988888. Yes, you can also get on a call with us and ask your questions directly from Michelle. So, Michelle, you have been a part of this immigration thing. You're an immigration attorney. It's been over, like I said in the beginning, over 12 years now. So you
And
have been.
16.
Oh wow, 16. Okay. So you have been an attorney for, and under a lot of different administrations and under a lot of different presidents. But this time it's something very different because people are really in dilemma, confused, worried, what's going to happen, what's not going to happen. And H-1B fee hike, something like $100,000, which nobody expected. So many things are going on at the same time. So, how do you look at it, being an immigration attorney who has been in this field for over 16 years?
Well, so what I always loved about immigration is it's administrative, right? And so we have laws, we have rules, we have regulations, and especially in employment based,
Mhm.
it was pretty objective, right? Discretion didn't really play a role. Most of the stuff was adjudicated based on eligibility, and
Mhm.
we had visibility, right, as to policy changes. There was a predictability I could share with my clients. Um, and employment based immigration was always looked upon favorably policy wise.
Mm.
That's been turned on its head by this president. It happened in his first presidency, and it's like 10 times worse right now. And this is all driven by Stephen Miller. And I have to say, I think it is just anti immigrant rhetoric. I think there is a very clear objective to reduce, if not eliminate, new immigration to the United States. And I think a lot of what drives that is the 2040 census indicating, or the census indicating that by 2040, minorities collectively will be the majority. And that has implications
Mhm.
for the electorate. It has implications for, what is the demographics of the country. And that's got a certain contingency of people worried that things are going to change too much. And
Mm.
so the reaction is restrictive.
Mm.
And we are now seeing that unchecked across all areas of immigration. And it's no longer something that's being said quietly. It's not being dog whistled. It's just very clear. This administration wants reduced immigration.
Mm.
That's what it is. And they're going to do everything in their power to reduce it, right?
Mhm.
So whether that means expanding the discretionary powers of adjudicators. We're seeing that across citizenship, for example, where now discretion can take into account whether or not they think that your parking tickets means too many speeding tickets is an indicator that you don't have good moral character.
Mm.
So they're expanding the use of discretion. We're seeing visa bans and travel bans against certain nations that maybe have a high rate of overstay or visa violation.
Mm.
Um, we're seeing restrictions on certain programs, or, indirectly with like this $100,000 fee, it's essentially killing all new H-1Bs. Now, one thing that I think is very interesting is it only applies to new H-1Bs. It does not apply to people who have existing H-1Bs. It doesn't apply to amendments. And there is an argument that it won't apply to changes of employers. So what
Mhm.
does that tell us? The administration is okay with the millions of people that are in the United States currently on H-1B. They
Mhm.
just don't want more people on H-1B unless it is someone that is so necessary that it could justify paying this $100,000 fee for a corporation to hire them, right? I mean,
So, so now, do you think it is going to be rich versus skilled? When we're talking about immigration and how things are going to be in the future, so is the immigration system going to change from skilled immigration or skilled immigrants to rich immigrants now? Okay, I think we have lost the connection with Michelle, but I hope she joins soon. Okay, we are. Okay, there's the connection is absolutely all right with us, but there seems to be some problem from Michelle's side. But I think she's going to tackle it soon, and she's going to come join us back very, very soon. But meanwhile, if you have any questions that you would like to ask Michelle, please continue posting them in the comment section. I see Ricky's question, Shree's question. So hi guys, and Samantha is also here. Hi all of you, I hope you are enjoying this show. And we are having Michelle here for the very first time. She's very excited, I'm very excited. I have a lot of questions ready with me, and I see you guys also have a lot of questions ready with you. But with that, if you don't want to post your questions in the comment section, but instead give us a call. So you can also give us a call on the number, which is 425-436-6335. But if you want to get connected with us on this number, you also have to put the access code, which is 988888. Yes, you'll be also able to give us a call, and we can directly get you connected with Michelle, and you can speak to her directly and ask your question, whatever that you have in your mind. And yes, but she's going to join us very, very soon. These technical glitches, all of these things, internet, all these technical glitches are a part of life. It sometimes happens smoothly, sometimes there is an error, but she's going to be back soon. But now let's go for a short break, and we'll be back after Michelle joins us back. We are going to come back after the break. But until then, you guys stay tuned with Immigration Talk Show. I'm Rajni Bharara, waiting for you all here.
You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support. You know why I'm vacationing in Dubai right now? Because I stopped drowning in RFEs, intake calls, and late night filings. I used to hire freelancers who barely knew what a G28 was. Total chaos. Then I found IMI support, virtual immigration paralegals trained in real case prep, docket-wise, and USCIS workflows. Now my calendar's clean, my clients are happy, and my firm runs while I relax. You can hustle or you can outsource smart. I chose freedom. I chose IMI support.
Hello?
Control here, ma'am. Everything okay, ma'am?
We lost Comcast.
Okay, I think Michelle, you're back. I was thinking,
No, we lost Comcast.
oh, for
All the
some reason
internet
we
went
can't
out
hear
in the
you. I don't know.
neighborhood for the last 2
Oh, okay,
minutes. So
no,
I
I
had
can
to.
hear you fine. Okay. Yes, I can hear you fine. I'm so sorry. I muted because, I put my laptop on mute because, I was on a call with Alyssa, but yeah, now everything is fine. So glad to have you back. We were
We
thinking
should be
of
good now.
had to reschedule, but I'm so glad
Let
that
me just have my
you're back.
husband. Can you check that we're on the right network? Okay.
Okay. I think everything is good.
Please reconnect.
So, Michelle, can you hear me fine? Control, am I audible to you? Okay. Maybe we can go on a break and then Michelle can, again, fix this sound issue and then we'll be back. Guys, please don't go anywhere. We are going to be back soon.
Okay, so I leave and log back in.
Yeah. Can you hear me fine now? Guys, there's this technical problem which is happening, so please be with us. Don't go anywhere. We are going to start the show very, very soon. Michelle, can you hear me fine and see me fine now?
I can.
Okay, perfect. So we are good to start then.
Okay, sorry about that.
No problem. I know it. Internet, happens everywhere. So understandable. That's completely fine. Okay. So, Michelle, we were talking about how the situation is right now and how is it going to be in the future and what's going to happen and what's not going to happen. And I actually wanted to know that do you think because of all these fee changes and fee hikes, do you think now the immigration system might be divided into rich versus skilled immigrants?
It's hard to say where out. I think this is, but there are a lot of corporate interests that depend on these. So there's a strong inclination in the business community. These fees won't actually come is more stable and that the system and the administration is sort of shaking it up to be. So I don't think we're going to go in that direction, but I do think that there is an interest by the leadership of this administration to push us in that direction. I just don't think that it's easy to change a system that's been around for decades so quickly overnight.
The future of the immigrants, I mean, the people who want to go to US now looks a little worrisome and
really
it
bad.
looks a little, people are, confused whether now they'll be able to or not. But what about the immigrants who are currently in the US or maybe, who have been there in the US for maybe a decade or more? So how does the future for them looks like?
For immigrants that are already here?
Yeah.
Well, I think we're going to see more retrogression, or not just for retrogress countries like India and China, but I think for rest of world. I think we're going to see, a lot of uncertainty as the administration tries to push policy changes and get pushback from the courts and corporate interests. But I think eventually this is all going to come to a head. And my hope is that at the end of this administration, we're going to see actually create a solution, because this is just too much chaos and too much uncertainty. And maybe it's, maybe I'm being too optimistic, but my hope is that it forces Congress, who for a long time has known about these issues, backlogs, particularly for the Indian community, have been a problem for 2 decades. DACA, the complexity of our immigration system, not allowing for or facilitating people who fall out of status or violate their status, correct the situation. I think that something is going to have to be done, and as much as this administration wants to scare people, we're talking about 30 million immigrants, right?
Yeah.
There are 10 million immigrants that are maybe undocumented, but there's another 20 million or so that are here on visas, and who are the parents of citizens, and that there's it's not an easy fix. So I think the administration is trying to scare people away, scare people from coming, scare people into leaving, and it's going to be kind of rocky, but eventually it's going to settle, and we're going to have to come up with a permanent solution, because that's not a solution.
Because
So I would just tell people, stick it out and keep doing what you're doing.
Okay, because like I was saying, that every time a new administration is going to come, they might change rules and policies, as per their wish and their will. So there has to be a permanent plan and a permanent way to do things right?
Correct. I mean, the law is still the law. These visas still exist. They may be more challenging. It may take more time. It's going to cost more money, because in our industry, if I have to spend more time, it's going to cost my clients. My time is my, but at the end of the day, the only people who can change the laws of immigration are Congress, and Congress is notoriously inefficient. So I think, things will continue as they are, and people just have to keep doing things the way that the law permits.
Okay. Thank you so much for answering the question. Michelle, also, before I ask you this question, I would like to actually tell you that just yesterday I was doing this show with an attorney, and the attorney, when I asked the attorney that what would you like to suggest the immigrants about how should they plan for the future, now that now everything looks chaotic, so how should they plan the future, and what should they do to keep everything in check? So what the attorney suggested was to maybe start planning to move to another country, maybe Germany, because that's like a good time in Germany. I mean, currently it's a good time for Germany to move to Germany. But if I were to ask you the same question, what would you like to suggest the immigrants? I mean, to have a safer future and to plan better, what should they do?
I mean, I think it's going to be a decision for each individual family. If you came to this country recently and you came on a humanitarian process, and the only thing that you have that you can petition for is something like asylum, I'm going to tell you, in this current climate, you're probably going to end up deported in the next couple of years, because that's what this administration is pushing for. That's an area of discretion. Historically, asylums have very low approval rates. And I think it's just going to be harder to win those cases. And the benefit of asylums was that they took forever, so people were able to build a life here for a long time. But I think this administration is trying to change that. So in those avenues, I think those individuals need to think about, is this really the safest country for them to start a life? Maybe a country that's more welcoming to refugees or asylees would be better. For those who are investors or skilled workers, professionals, I think the United States still offers a tremendous opportunity, but it's not going to be cheap. It's not going to be easy. It's going to be a struggle to get here. But that's why people want to come here, because the struggle and the investment is worth it. The return on investment for a lot of people is really high. So, yeah, sacrifice. Yes, you're going to have to struggle to get here and to stay here. But you also benefit a lot from the opportunities in our economy and in our society. So it's a give and take. But I think people have to come to terms with is that immigration is not going to be cheap and easy. That's just not the reality of our system. It never really has been, but there were a lot of, I don't know, loopholes or inefficiencies that allowed people to stay somewhat comfortably without a fear of retribution. And I think that's what's changing.
No, absolutely. That's why it's called the American dream, because even though there are so many alternatives, but people still prefer to go through all the hassle and everything, all the problems and all the hassle, like I said, and they still want to achieve that American dream because everything is worth at the end. And
Right.
every risk is worth at the end, right?
And I think that's what makes us proud when we finish the journey and we become citizens, why you see such patriotism
Yeah.
from people who become naturalized citizens, because it's a huge achievement. They really struggled to get there, and that's part of the pride of being an American. I think that's been part of our ethos, right? Like hard work and the reward that comes with it. So in some ways, I support it. I think, the anti-immigrant rhetoric is unnecessary. There is a lot of, wise, a lot of noise, but I don't think that's the day-to-day reality in our communities. You're not seeing hateful racism or discrimination, in the workplace and in the streets. So that's not the reality of our country.
Absolutely, absolutely. Thank you so much again for answering the question. So now I would like to move to the viewers' question because they have been patiently waiting to hear from you.
Of course.
So Ricky, let's start with Ricky because he has posted a lot.
Ricky was the first.
Yeah,
so Ricky gets the question first.
Right, right. So Ricky, okay, so your question is displayed on the screen, and what he asked is, "Hello, thanks for the session. Will 100K have to be paid for case of concurrent H-1B filing by a second employer after 24 September?"
So this is an interesting question, and there really is no clarity, because if you think about it, if you already have an H, and they've said that amendments and arguably changes of employer are not new H's. The other thing that's interesting is that the administration can impose the fee on admission. So the area that they're using is a provision of the law that says the administration or the president can control the entry of immigrants into the United States. If someone is already here on an H and they are applying for a concurrent H, the argument is this is not a new H and it's not controlled by 12F, which is the authority under which the administration is claiming they can impose this $100,000 because the person's already here. And so I can process that concurrent H the same way I can do a renewal without having to leave and enter the country. And so there's no authority to impose this $100,000 fee on anyone that's in the United States under 212F, right? So I think that this is all going to play out, is that unless Congress passes a law to authorize the fee, this $100,000 fee is only going to be able to be applied to people that are outside the country and are trying to get an H stamped at a consulate to come in. I think it's going to be very difficult for them to successfully impose this fee on H-1Bs, even new ones that are filed within the United States as changes of status. So I think the straight answer is it's unclear whether it will apply to concurrent H's. That has not been, the policy is very vague. But there are arguments that can be made that is related to an existing H which there is clarity. Anyone with an existing H will not be subject to the fee.
Okay. Okay.
So
And he
the
also
answer is maybe.
maybe and maybe not.
Exactly.
Yeah, okay, okay. But he still has more questions. So he also asks that I am in the US and plan to travel to my home country for stamping. Will those with approved H-1B have to pay 100K after first time visa stamping in their home country upon entry in the US?
So the $100,000 fee only applies to H-1Bs that are filed with USCIS after that September date, right? So if you had previously filed your petition and it's been approved, then that's a visa fee petition. When you go to stamp it, you're not subject to the 100,000. And my suggestion would be to take your petition, circle the date it was filed, print the whatever the consulate you're going to post at. They have provided guidance on each of their websites as to how they're going to implement the policy. The Department of State also has on their website a clarification. This will not apply to any H-1B petitions that were filed before the cutoff date. So if your receipt shows that your case was filed before the date, it doesn't matter if this is the first time you're stamping the H. What controls is the date it was filed with USCIS.
Okay. Okay. So, Ricky, I hope you have got your answer. And he has another one which says, is the gold card a replacement for the EB1 category in the future? How does it relate to the green card? Can those buying the gold card bypass the EB1, EB2 queue?
So this is really interesting. It hasn't been litigated, and the kind of like got slipped in behind the H-1B fee, right? Because they were both at the same time, but no one really paid attention to this one. Also, the proclamation does not give clarity on the number usage. We're getting this from comments that Lutnick put out. And so here's how my deep dive into this, what the strategy is.
Mm-hmm.
The gold card is an EB1 or an EB2. They're claiming that the $1 million contribution is evidence of national interest, presumably for those that can show either 10 years of experience or an advanced degree or equivalent. Or in the alternative, it's like the equivalent of one-time prize, which is the criteria for the EB1. So what they're essentially saying is that discretionary factor to approve an EB2 national interest waiver or EB1 based on, having accomplished something, that $1 million contribution is evidence of that. Second, they're premium processing it, essentially. Third, they're using the EB2, EB1 numbers for these visas. So the country quotas will still apply. So based on nationality, but if you're pulling an EB1 number, now you're not necessarily having to prove all the EB1 criteria. You're just giving $1 million, and then you get the same quota priority date as an EB1 national. And then they're, actually premium processing it. So they're doing everything within the existing framework Congress has established in terms of category, quota, processing times, visa availability. They're just saying that the $1 million contribution is that discretionary factor that proves either national interest or extraordinary ability. And so they're using those numbers for the gold card. Now, the part that's concerning, and this was what we had talked about when we were preparing the questions, is that Lutnick said he is going to reserve 80,000 of the 140,000 green card numbers in employment base. And for those of you that don't know this, basically across EB1 through EB5, we have 140,000 visas available per year. Every petitioner, along with each individual family member in the group, takes one number when they get a green card. And once those 140,000 are used up for the year, it creates what we call a backlog, but people get in line for the next year.
Mm.
We also have country quotas. So based on your country of nationality, no country can take more than 7% of the annual employment-based visas in a given category. So that is another limiting factor that can, for certain countries like India and China, where we see a lot of applicants, it creates a long line. Those criteria are still going to apply, but now what Lutnick has said is, I'm going to take 80,000 of those 140 and I'm going to set those aside for my gold cards. I don't know how he's going to do that, but he's essentially going to, if he effectively is able to do it, mean that instead of having 140,000 visas available for the many applicants we see each year in these categories, it's only going to be 60. And so that tells me that if he is able to reserve 80,000 for his gold card, I mean, the same unused rules will apply, right? If he doesn't use them all, they'll roll over into the next year. But if he sets aside 80,000, that means the rest of our candidates who are normally applying for EB1, EB2, EB3, EB4, and EB5 are going to be fighting over 60,000 versus 140,000 visas. And I think that's going to create a significant retrogression. Now, all of this will depend on them actually getting 80,000 people to pay $1 million, which I don't know if they will. I'm sure there are a lot of people, high net worth individuals who maybe were caught in the backlog, in the EB2 and EB3 backlog, that maybe this is an option for them, right? If they have $1 million to contribute and they are stuck in the backlog in EB2 or EB3, maybe they didn't qualify as an EB1 because they didn't have the recognition, but they have the money, they can essentially buy their way into a more current category. So I think that's where we're going to see the spending. And maybe, companies like Meta and Facebook will want to do that for their high-level CEOs, because what's happening is they've offered that if a company pays $2 million, they will be able to access those visas for their employees. And then they don't have to pay $1 million per employee. They just pay a certain amount per employee. That's unclear to me what that amount is going to be.
Okay.
So so I think the gold card isn't the replacement for the EB1 or the EB2 or the EB5. It is an EB1 or an EB2. I just think it's a different way to qualify for EB1 or EB2. You're basically buying your category.
Okay. But then EB1, EB2, EB5, they are still going to be an option.
Oh, yes. The only way they can eliminate those is through an act of Congress. But what they are doing is by carving out, by saying we're going to hold 80,000 of those numbers for EB1, EB2. And I don't know if they're going to be successful in doing that. But by doing that, they are making the timelines for everybody, or the backlog, longer, because it's going to take twice as long if we only have half the number of visas available.
Okay. Thank you so much for answering the question in such a detailed manner, Michelle. And let me again go to another question that is posted by Ricky. He also goes on to ask about NIW I-140 has been pending since last 12 months. So what would you suggest at this time, given filing a premium might lead to an RFE, as officers might not be reading the petition carefully?
So there's a trend that I've been seeing in the last year. The administration has been pushing a lot of senior officers out, either by terminating them or just making work conditions uncomfortable for a lot of people. And the strategy is to get rid of the more experienced officers that are at higher wage levels and bring in newer employees at lower levels, enticing them with bonuses, but also changing the training. So we're seeing a lot of training issues, and we're also seeing tons of RFEs. Almost every case lately is getting RFE'd. They're template RFEs. It's like nobody's reading anything. And we're getting a lot of noise, right? So you're skip the RFE, we're going straight to a notice of intent to deny.
Yeah.
That trend, I think, is going to continue. I'm seeing it in EB1s, I'm seeing it in EB2s, national interest waivers, I'm seeing it in O's, right? So these are the discretionary visas based on talent. In terms of an RFE, I think you're going to get an RFE whether you premium process or not. And I think it's going to be tough to get an approval in this climate. We were seeing at one point 2 years ago, we were at like over 90% approval rates on our national interest waivers. Last year, we dropped to 86% towards the end of the Biden administration when they were sort of tightening up on the STEM cases. And this year, we've dropped to, I think the last tally we did for year 2025, we're seeing a 67% approval rate. Now, I have colleagues that are reporting 30% approval rates. And that's, I think in part we have a higher approval rate than a lot of our other colleagues because we're more selective about the cases. In terms of, I don't do a national interest waiver just because someone has an advanced degree or 10 years of experience. I'm really looking for them to show me that they work in an area that is of national importance. I'm looking to show that they can show the benefit of the balancing test, why it's in the national interest to waive the labor certification requirement, why it's not practical to do the labor certification. So there's a lot of different elements that I look to prove, not just the basic eligibility criteria. And I think that's why we have a slightly higher approval rate than a lot of our colleagues that basically are willing to do any case that the client wants to try. So the short answer is, I think you're going to get an RFE either way. What is the strategic benefit to you of accelerating that adjudication?
Okay. So, Ricky, I hope you're prepared for that. Thank you so much, Michelle, for again taking that up. And he still has posted a lot of questions, but Ricky, I would like to give a rest to your questions for now because there are others also in line waiting for their turn. So let me quickly take others' question, and then at the end we are again going to move back to yours. So Shri has also posted her question, and Shri says, "My priority date is August 2015 in EB to India. Planning to switch the employer now and restart the perm and I-140." With new employer. The process may take 2 years. Do you think EB2 will cross 2015 soon?
No, it's really hard to say. So when Charlie, the guy who used to run the numbers at Department of State, name was Charlie. I'm friendly with him. When he was running the numbers, we had better visibility. We'd have stakeholders meetings with Department of State where he would talk to us about the visa bulletin, and we had a better understanding of where the numbers were coming from, right? And the way Charlie explained it to me was they would look at the priority date of the last petition adjudicated and granted an immigrant visa, whether it's at the consulate or as an adjustment. So the number is issued when either the consulate grants the immigrant visa or when USCIS grants the adjustment of status. The priority dates are not set based on what they see in volume ahead. It's historically, he'd say it was just based on the priority date of the last case adjudicated. And so they would just move along down the line in that range based on whatever volume they had. I don't know what they're doing now because they're not really explaining it. The visa bulletin isn't detailed. Like, I don't know if you remember many years ago, when the visa bulletin, there'd be these paragraphs that would explain to us what's going on in, rest of world, what's going on in India, what they're seeing in predictability and increases in different category applications. We don't have that kind of information like we used to. And the retrogression has been, I don't know, a little unusual. For example, rest of world normally, and in all the categories, the October bulletin normally sees a big advancement because that's when we get our 140,000 numbers.
Mhm.
And this year we did not see that, right? Certain categories advanced, but a lot of them didn't. Now, a part of me is suspicious that maybe Lutnick had made a comment that EB1 and EB2, as soon as this month, and he said that a month ago, they were going to hold back the numbers to reserve 80,000 for his gold card. So maybe that's why we didn't see EB1 and EB2 advance, but it doesn't explain why EB3 only advanced in rest of world for a month. And then with India, we saw a big jump under the Biden administration, and that was very exciting. But then we saw an almost immediate retrogression because they received so many applications.
Yeah.
So it's hard to say. I also think what's complicated is the filing versus final action chart. When Charlie was so managing the numbers, we used to push him and say, listen, if processing times are 36 months for an adjustment of status, then the filing chart should be 36 months ahead of the priority date, because that's how long it's going to take you to get to that case anyways.
Mhm.
Right? So our advocacy had always been the filing chart should be used, and that filing date should be X amount of months before the final action date based on what your current processing times are. And right now, adjustments, I think I looked at one service center was publishing 52 months for an adjustment of status. So I think, we don't have clarity as to how they're using the final action, the filing charts anymore. The filing chart, it's the first time they've used it this year was this month, which I thought was great. But I don't know what we can anticipate. I don't know what Lutnick's going to do with these numbers, and how he takes those numbers could certainly affect whether we're going to see an advancement or not. And I've been, I have a lot of clients from Europe and Latin America, and I've been telling them, they're like, oh, well, my priority date is, it looks like it's going to be available within a year. And I'm like, it could be a year, it could be 3 or 4 years, because I think that there's been an increased volume of applications and we don't have the visibility. So I think it's going to be very hard to predict what the movement is going to be right now, because I don't think they're following the formulas that we've historically seen used. There was a time where I could look at the USCIS statistics. I could see what the inventory was. I could see how many cases had been filed in the previous year. I could say, okay, so based on how many cases we know were filed in this year, therefore have that priority date, we can anticipate this kind of movement. I don't think that's how it's working anymore.
Yeah, exactly. Because everything seems very unpredictable right now. I mean, especially at this point of time. So, yeah,
Right.
very well
And
said.
we're not getting clarity either, right? They're not telling us how they're doing stuff. So it makes it even harder for us to advise clients.
I mean, do they know that what's going to happen or what's not, or maybe they are also doing it out of spontaneity and just being spontaneous and doing things.
Right. I mean, that's the feeling I get. I don't know who's currently running the numbers at Department of State and what the formula that's being used is. I said with Charlie, he was very transparent and we knew how it worked. He sort of let us look behind the veil. But even in his post agency role, where I know he's a speaker and an expert on things, he says it doesn't match what he was doing in the past. So they're doing something different and we don't really know what that is.
Well, the future does seem very scary and very, unpredictable right now. But still, thank you so much again for taking that up, Michelle and Shri. I hope you have got your answer. But if you're still looking for still looking for an answer for one of your follow-ups, so you can please post your follow-up in the comment section. Meanwhile, let me take Samantha's question. Michelle, I hope you have some time because we still have a couple of questions to take. So
Yes,
will it be
absolutely.
okay? Great. Samantha's question is filing under EB2 with National Interest Waiver a better option than waiting for EB1 for someone in a tech research field?
Well, that's a tough one. I mean, I think it's really going to depend on your criteria, your qualifications, right? If you have, I think you need to sit down with an attorney that does a lot of EB1s and EB2s. And you're going to have to look at what's your particular recognition in your field versus the impact of your work, right? So a national, if you have an advanced degree, whether you're doing an EB1 or an EB2, you're going to look to see which criteria you can document. On the national interest waiver side, it's going to be more aligned with what is the impact of your work? Is it of substantial merit and national importance? And is there an urgency to waiving the labor certification requirement in your case, either because it's not viable or because the work you have to do requires you to have a green card and it's going to take too long to get the labor certification process. But if you're in a backlogged nationality, that argument of the balancing test is really hard, because whether or not you do the labor certification, it's not going to advance significantly the time to get your green card. So I think that's been one of the challenges for the national interest waivers on backlog nationalities, is that one of the big arguments for waiving the labor certification was with the time it takes to 2-year wait. But since that doesn't really affect the visa availability, that argument's fallen flat. So it's going to be more focused on, does your work require you to work independently such that you cannot perform your work as an employee and a labor certification isn't practical? So that would be the analysis under the EB2. On the EB1, you're looking to see the strength of your qualifications in one of the either extraordinary ability criteria, or if you're doing the EB1 as a researcher, how published you are, your citations, how relied upon that is. So each one of those categories has its own criteria. The benefit of an EB1, if you can qualify, is that the priority dates are more current. But again, if you qualify. So there really isn't an answer that is general to this question. It's very specific to the individual's profile.
Okay. All right. Thank you so much, Samantha, for your question. Let me quickly move on to, okay, so Shri is back and Shri says, thank you for the detailed explanation. Do you think it's risky to switch the employer now and get the perm?
Okay. My strategy is always perm. Perm is the most secure route to a green card. The problem has always been and continues to be when the person is in retrogression, you got to stick with that employer, right? Because you're always tied to that employer. But the benefit is you can recapture your priority date. So if you're switching employers and you already have a perm with that employer, doing a new perm with a new employer isn't going to hurt you if you can recapture that priority date, right? That's the key. And I always think if you've got an option between an EB1, an EB2 national interest waiver, or a labor cert, go with the labor cert. That's got like a 99% success rate. Of course, if you're working for a startup or a company that isn't stable, maybe that's not the best option. But if you're in a retrogressed category, then at least you can get your priority date locked in and use it again with your next employer. So I'm always going to say, do the perm. And in terms of switching employers, don't switch employers until you have confirmation, if you already have a perm with your current employer, that other employer and written commitment that they're going to do a perm for you, because you don't want to jump ship to a company that isn't going to give you the protection you need long term. So that would be the considerations.
Okay, so maybe perm can help her in being permanent.
Yes.
Okay, thank you so much, Shri, for your question. And okay, Robert is also here. Robert says, if I switch employers now, how could it affect my H-1B status and any future green card applications?
Well, I need a little more context, but if you are on an H-1B and you switch an employer, I will say that the administration is going to look at your case, what we say de novo, right? So maybe you already had your H approved under the Biden administration and it was fine. Now they're going to apply a new standard or their current standards in re-adjudicating your H. So just because you had a prior H approved does not guarantee an approval on a change of employer. So that's the risk. And obviously, if you don't have H-1B status, that will affect any future green card applications because you can't adjust status if you're not able to be in the country lawfully. So I think that's the only issue that we've seen with changes of employer is, sometimes if you had like kind of like a questionable specialty occupation job, also looking at the ONET codes, a lot of positions were downgraded. So maybe you were like a zone 4, zone 5 professional position before, but now it's a zone 3. So you'd have to do it in a different position. The wage levels are changing. So all of those things are things to consider when you do the change of employer. And I would just double check with an attorney that does a lot of H's to make sure you are clear on those risks before you do the jump. And something that I always recommend is you can file a change of employer before you leave your current employment. And that's how you should do it. I would wait until that change of employer is approved before you change or resign your job, because if it doesn't work out, then at least you can stick in your current employment.
Right. Okay. So, Robert, I would suggest you to get in touch with Michelle herself. There is this link which will be displayed on screen shortly, and this is the bit.ly link which will take you to her website. So you can, join this link, click on this link, and visit her website. And yes, you will find all her details over there, and you can directly get in touch with her and ask all your queries in detail. So thank you so much for your question. If you have more questions coming, please keep them posting in the comment section. I know Michelle doesn't have much time, but we would
on
definitely.
our website, you can book appointments directly. We do have a questionnaire that we ask you to fill out, and you can upload. I believe you can upload documents that you want us to discuss with you on the call. And we do charge a consult fee, but that consult fee is discounted from any process that you hire us to do. It's just to make sure that, if we're spending time with a client, and I always make sure that I spend my 30 minutes or more with the client to ensure that they understand what we've discussed, that time is being spent fruitfully. And if you don't end up using our services, at least you got the information. And if you do use our services, then we'll discount the time that we spent in introducing the options to you from your case.
Perfect. There you have it. So please make sure to get in touch with her. And yes, thank you so much again for posting your question. And I think I know, Michelle, you don't have much time, but we would love for you to be back with us for another show. And because we have a lot of questions that are pending, and some of them are from Facebook, which the users have posted, and then some of them are my questions, which I would love to ask from you again. But I still have one more question that is from LinkedIn. So if you have some time, maybe I can take that one last question.
Yeah, of course. And if you want, you can send me the questions, and maybe we can do a little FAQ that you can share with your followers. But I'd be happy to come back on.
So sweet of you. Thank you so much. Thank you so much for saying that. Okay, so here's a LinkedIn question. So this is from the viewer called Chandrasekhar. He says, one of my buddies came to the US with employer X in June. His project ended due to some budget issues immediately, and he stayed here till November with his employer. Now he's planning to go back to his country and planning to come back. What are the documents or points he should consider while returning with new employer?
So I think the first thing he needs to do is make sure that he didn't accrue unlawful presence or commit a status violation when he was laid off. So there's something that we call benching. If he was here, for example, on an H-1B, if they basically kept him, they stopped paying him, but he was here still technically as an employee of the company, and he had his I-94, an argument could be made that he wasn't violating his status and he didn't accrue unlawful presence. But that's something that a lawyer has to really look at. Now, it seems it was less than 6 months. So even if he did remain in the United States beyond his period of status, it didn't trigger a bar because it's less than 180 days. But when he goes to his new interview for the H, he needs to be prepared to explain what happened, why he was laid off, why he stayed and justify that period of time as not being a willful violator, because that could be a problem for him in applying for a new visa. And we've been seeing that lately with H-1Bs. They're denying them if they think that the person is somebody who's going to violate the conditions of the visa. So if he's, somebody who stayed without working on the H, they could try to use it against him. So I think, maybe documenting that there was a layoff, but it wasn't a permanent layoff, that they were saying that he was going to be rehired. I don't know what the circumstances were, but I think he should work with an attorney to make sure that he can defend why he stayed after June when the project ended, and ensure that he can document that he wasn't in violation of the conditions of his visa if he can.
Okay. Okay, great. So Chandrasekhar, I hope you have got your answer. Thank you so much. Thank you so much, Michelle, for patiently answering all these questions. And like you said, that you would love to be back. So, and we would love to have you back very soon. So, because how about we do a part 2 of this episode? Because we still have a lot of questions pending from Facebook and also from my side.
I think H-1Bs are a hot topic always.
Yeah, absolutely. And especially, at this point of time.
H-1Bs and perms.
Yeah, absolutely.
I live and breathe them.
Yes, absolutely. Thank you so much again, Michelle, for being here. It was lovely, having you for the very first time. It was a blockbuster episode, and with such an insightful discussion. So thank you so much, and you please take care, and hoping to see you very soon.
Thank you so much for having me, and feel free with any follow-up questions. I'd love to be back and talk to your viewers, and it was really fun. Thank you, and sorry for the technical difficulties. We'll do better next time.
Thank you so much. Thank you.
All right. Bye. Thank you.
Bye. Okay, so guys, thank you so much for posting all your questions and for participating in this webinar. And I hope you enjoyed this session as much as we did. And like I said, it was a blockbuster episode because it was filled with insights. And we are going to have Michelle back very soon. But if you want to directly get in touch with her, you can visit this bit.ly link. And yes, you will get her all of her details over there, and you can book an appointment, like she said, and visit her website. Thank you so much for participating, and we are going to see you very soon. But until I see you again, make sure to like this video, share this video with anyone who you think can benefit from this information, and don't forget to subscribe to Immigration Talk Show. I am Rajni Bharara, your host, signing off for now. Take care and goodbye.